ये तो डिसाइड हो गया केस
सर एक बार डिसमिस हो गया था
हाँ
thereafter they have restored this thing and it was restored in the year 2020 and then still उसके लॉकडाउन हो गया था and now it somehow it has been listed सर ट्रायल held up by and इसमें जो एप्लीकेशन है दो इम्प्यून ऑर्डर्स है जो वो चैलेंज कर रहे हैं 311 और 91 का एप्लीकेशन लगाया था which was dismissed and subsequently they have preferred revision that was also dismissed on the account.
बताइए इनको बताने दीजिए इनका केस है प्लीज आर्ग्यू
Lordship, we have filed application under section 91 and 311 in which in application under 311 we were requesting to summon the complainant to examine the complainant and under 91 we were asking for documents related to his educational qualifications. Because at later stage after the cross examination of the handwriting expert, subsequent development have taken place and those could not be examined at the time of complainant cross examination. Therefore we were praying for cross examination to call complainant again, and in complainant's cross examination he has stated several times that the check was written and given to him, signed and written, filled and given to him by the accused in front of him, but the accused is 8th fail and he don't know how to read and write English, and the check was completely filled in English language and it was signed in Hindi. And we have also produced document which regarding the qualification of accused, which says that he is 8th fail, but in
how you can establish that one person doesn't know English?
Lordship may see this cross examination.
Even illiterate person can speak English. English is a language, not subject.
But writing is different thing, no sir. Speaking is different, but he is not literate. He only knows Hindi. So how can he write? And in the
even printed check is valid. You can simply sign it if it is printed. So anybody can fill the check and you have to sign only.
I go down to your lordship that the presumption of section 139 that anybody can fill the check, and that is not a foundation. But the complainant in his cross examination has said several times in para number 8, 9.
How much is the amount involved in this?
7 lakhs. And our defense is that the check was we had kept the check in our car for some other purpose, and the check was stolen from our car. And
Any report was lodged? Any application was given to the bank that this check has been misplaced or stolen?
we have reported the matter to the police. We have given a shikayat avedan to the police, but police has not accepted the same. Lordship may see this.
किसको बुलाना है आपको? हैंडराइटिंग एक्सपर्ट को बुलाना है?
नहीं सर,
No,
that
Lordship, we want
Huh?
to call the complainant.
Complainant.
Yes.
He will appear in the.
Huh?
He has already appeared. You have cross-examined.
He had appeared. We had
Matter and madam.
cross-examined.
Yes.
But Lordship may hear me.
हाँ, hearing you. और क्या कर रहे हैं?
After the complainant was cross-examined, we have moved an application for handwriting expert test. Then handwriting expert
To examine what?
To examine the check handwriting.
That is not relevant. Yes.
But we have also got the check handwriting examined, and the respondent has also got the check handwriting examined. But the opinion were contradictory.
होगी वो तो जो जिससे लेके आएगा वो अपने फेवर की रिपोर्ट लेके आएगा.
And later,
Now the court is expert of expert. The court will decide.
But your lordship, some points are there which are necessary to establish my defense, to strengthen my defense. Therefore, I am requesting to allow this application.
ट्रायल अभी भी पेंडिंग है?
Yes, your
Sir,
lordship.
क्या स्टेज है?
Sir, it was on the final hearing stage.
Hmm.
They have moved this application
Hmm.
and they have taken stay. मतलब इसमें stay मिल गया है सर somehow. And तब से लेके सर ट्रायल चला ही नहीं है. From
Lordship.
last 4 years, not even an inch because of the interim
तो
protection.
इसके तो 2020 में वेकेट हो गया
Yes,
था।
सर वो हो गया but they are saying कि क्योंकि restore हो गया है हमारा केस, therefore that stay is automatically now again revived.
तो रिस्टोर कब हुआ?
We
सर
have not,
रिस्टोर 2020 में जब ये इनका पिटीशन वापस से रिस्टोर हुआ है.
अरे डिसमिस 2020 में, रिस्टोर कब हुआ?
सर 2020 इनका
lordship, it was dismissed
सर 23
on
2020
23/2020, and just after that lockdown was announced. On 11 February 2020, it was dismissed.
चलो ठीक है।
And lordship, as far as the senior counsel is saying that we have caused the delay after filing this application and after getting the stay, so that is not the point, because they have not appeared once even after filing the stay application for vacating the stay application.
sir, off record things, and if one record sir on
So that-
चलो ठीक है, दैट्स ऑल। 311 की एप्लीकेशन आपकी ये है, और जो तो किया गया और जो तो कोई महत्वपूर्ण नहीं किया गया। चलो इसमें 311 मैडम, कोर्ट्स डिस्क्रिशन टू कॉल द विटनेस, यू कांट फाइल एन एप्लीकेशन, इट इज फॉर द कोर्ट टू डिसाइड कि वेदर एनी विटनेस इज टू बी एग्जामिन और री एग्जामिन। और कोई रीजन आपने नहीं असाइन किया इसमें एप्लीकेशन?
Lordship, I have assigned the reason.
कोई रीजन नहीं लिखा कि कुछ क्वेश्चन छूट गए हैं, दैट इज नॉट
Lordship, I have also
ऐसे तो
mentioned that
never ending trial होगी, लिखिए।
subsequent development has taken place after
तो
cross
वो
examination.
कुछ प्लीड नहीं किया उसमें। लिखिए, पिटिशनर ऑब्लिक एक्यूज्ड हैज फाइल्ड दिस प्रेजेंट पिटिशन चैलेंजिंग द ऑर्डर dated 17/9/2018 passed by JMFC in a complaint case 144 of 2015, whereby application filed under section 311 for recalling of oblique re-examination of complainant has been dismissed. Thereafter, the applicant preferred in criminal revisions 463 of 2018 before the session court, and while order dated 24/4/19, the same has been dismissed. Hence, this revision before this court.
480.
The 482 petition before this. While order dated 24/6/19, this court state the further proceeding of complaint case, but thereafter by order dated 11/2/20, MCS this case was dismissed for want of prosecution. Later on it was restored. Para. The applicant accused filed an application under section 311 for recalling of complainant for further cross-examination. The only reason assigned in the application is that on 24/8/2016, the complainant was cross-examined by the counsel, but he did not cross-examine on various important issues. There are some development after the report submitted by the handwriting experts. Therefore, in the interest of justice, the complainant is liable to be recalled for further cross-examination. This is not an scope of section 311. 300 section gives power to the trial court to call any witness for examination, re-examination, suo motu, not on application by any person. Even otherwise, on the basis of the such an vague pleading that certain important issues has been left for. A cross-examination has not been done on some important issue. The witness cannot be recalled. Otherwise, it would be a never-ending process. Therefore, the trial court as well as session court both have not committed any error while dismissing the application.